and a short while ago, I spoke to the president of the Assembly of State Parties, Tina Intelman, via Skype, and I began by asking her what this latest decision would mean for the Kenyan cases.
We do not want to do the job of the judges, and the court is an independent judicial institution. So what will happen now is it is absolutely up to the judges to interpret these rules of procedure and to see how they will apply to ongoing cases and also specifically the Kenyan cases.
All right, so let's still look at the resolutions that were arrived by the Assembly of State Parties. And then there is the concern. Is this a sign then, ma'am, that state parties are politicizing a legal process? Because the men who are suspects at the International Criminal Court, by the time these cases are coming through, they were ordinary Kenyans. But right now, one is a president, one is a deputy president. Then you have the scenario of the African Union getting involved. Do you see a scenario where state parties are now politicizing what is essentially supposed to be a legal process?
Well, according to the Rome Statute and the Rome Statute system, the amendments to the rules of procedure of the court are also in the competence of states parties. What states decided to do right now is to look at the current situation where important elected high officials are due to appear before the court, and how to create the possibility for these people also to carry out their state functions.
I know you have said that everything now remains at the discretion of the court. Question is there any particular moment at which the suspects will be required to be present at the court, even after these resolutions have been passed?
I am not in a position to say so. It is up to the judges to interpret these rules.
These amendments come, of course, just a few days after the appeals chamber said that President Uhuru Kenyatta will have to be present for his trial at the International Criminal Court. You now have the state parties meeting and saying, he really doesn't have to be there. He can be represented by his legal team. Is this, in a way, a rebuke of the judges and indeed the court? Is it sending a message that they have to be aware of the political and geopolitical issues on the ground when they're coming up with such decisions?
What I think we have seen over the past months is that the court itself, through its decisions, has been looking for flexibilities, trying to take into account the present circumstances. And the court has on several occasions said that the two accused should not be present at all times. On the contrary, they could be excused if they so requested. So now what the Assembly has said, I think the Assembly has further given to the court an indication of its flexibility in the rules. Again, how this will play out in the future, because we are not speaking about two persons here. These rules will apply to everybody. These are general rules that now the judge will be applying to concrete cases.
Madam President, let's now focus on the legality of the resolutions. And in saying so, I'm focusing on the issues that have been raised by the legal representatives for victims, that is Fergal Gaynor. And he said that any decision that the Assembly of State Parties takes must be consistent with the Rome Statute. Otherwise, the judges of the International Criminal Court can declare it null and void if found to be inconsistent with the Rome Statute. According to Gaynor, Article 63, subsection 1 of the statute imposes an obligation on the accused to be present in the courtroom for the duration of the trial. Article 27, subsection 1 requires that all provisions of the statute, including Article 63, subsection 1, obligation to be present at the trial, be applied to all accused without distinction based on official capacity. Are there chances, Madam President, that the judges of the ICC can declare the resolutions null and void?
Well, I am confident that we have very good lawyers sitting in the Assembly of States Parties. We have 122 states, and all of them were represented by outstanding lawyers who have been with their own statute. and negotiations also earlier and have attended assembly meetings. So I am in the hands of states parties. So I trust that what the decision that was made based on the collective wisdom.
Are you now worried that this sets a precedent for state parties, that anytime a state party will be uncomfortable with any provision of the court, they will seek to amend it in future?
Well, we have been amending the rules previously over the past years in consultation with the court, with the judges, and this was exactly also the case this time when we were negotiating amendments to the rules of procedure. That was done also in consultation with the judges of the ICC.